supplementary list, item number 1 for pronouncement of judgment.
Only you're there.
Yes, ma'am.
I'll read out only the two portions.
Yes, ma'am.
However, since this court is of the view that the structure of the petitioner was in existence prior to the construction of the said 33 kV line, reliance upon the said provision of so-and-so will not help the respondents. Section 10D of the Indian Telegraph Act 1885 provides for payment of compensation to all persons interested for any damage sustained by them by reason of the existence of those powers, meaning that the laying of any telegraph line or post causing prejudice, loss or danger to the occupier of the land would enable such occupier to be compensated. Be that as it may, under the peculiar facts and circumstances of the case of the petition parties herein, in an equitable approach to the case of the parties herein, this court finds it proper to allow the said 33 and 11 kV line at HT lines to remain as it is in the same place, since shifting of the same would entail an enormous amount of cost which would not be payable by the petitioner under the circumstances as has been indicated here and above. However, to prevent any danger posed to the structure of the petitioner or to the lives of the people occupying the said structure, the authorities in the Commerce and Industries Centre are directed to offer a suitable alternative accommodation to the petitioner for setting up of his industrial unit. To assess and quantify the extent of compensation to be awarded to the petitioner, the District Collector / Deputy Commissioner West Jainti Hills District hereby directed to take on this task by conducting an inquiry including inspection of the affected portion of the unit of the petitioner, and after hearing the parties concerned, to draw up the award due and payable to the petitioner. This exercise is to be completed within 3 months from the date of receipt of this order.
Hello. Oh, bless you.
Item number 2.
End of the vote.
In daily list, item number 1.
Mr. Kantar is appearing, please.
So you are ready with the hearing?
Yes, sir.
How long will it take? How long will it take?
It'll take some time. More than 1 hour it'll take.
See, because there's already a fixed matter, a part heard matter for hearing. I was thinking if this matter, so if they, it doesn't take time, of course I'll take it up. Otherwise,
I just want to enlighten something before Your Honor continue. My colleague, Mr. Muzika, yesterday we had a discussion. He was insisting that he will want to ask some instruction because all cases have been closed, have been disposed of. And the money which was seized by CID also, that total amount of is 10 crores, that also has been released. They have given the consent to release. It has been released to the Dorbashno in Shokwan. And the money, private money of Mr. Sandiwes Tumba also released. Now the enforcement directorate also have released everything. Now when they filed this appeal before the High Court against that single judge order, Your Honor, then in 2014, there they have said that by mistake they had filed this civil suit. A civil suit which was filed for recovery of 8 crores. Now that 8 crores civil suit was rejected on the ground of lack of cause of action. Because Forest Department is not the person who gave us the money, it's a collector. So there should be withdrawal of acquisition. So that appeal, I challenged the limitation. There was a delay in filing the appeal because more than 2 years. Here in the High Court, they are saying something else. There in the appeal, they are saying something else. But the same appeal was annexed. Now the point is that, in fact, there's nothing left for the Forest Department to challenge or to say anything. They wanted to ask for instruction whether to pursue, to go ahead or not to go ahead. I told him to.
The entire compensation amount is 10 crores. Lordship, wrongly it has been released to the petitioners here.
wrong person.
8 crores.
Because what has happened, Lordship, in this case, Lordship, the same land which belongs to the government itself has acquired that same particular land, Lordship.
That is not the case.
So, Lordship, what has happened? 10 crores was supposed to be paid as compensation. 8 crores was paid, Lordship. Now we had to file because of these discrepancies, Lordship, we had to file a recovery suit of 8 crores, Lordship. Now that suit was rejected on the ground that there's no cause of action. Against that, we had preferred an appeal, Lordship. Now that appeal was dismissed for default for non-prosecution. Against that, we had preferred an application for restoration. Now, while preferring the restoration application, there was a continuation delay, Lordship. So that was delayed. That was condoned. Now, against that order, the petitioner had approached this court.
So,
Lordship.
Your Honor, the remaining, it was 10 crores. 8 crores was paid initially by the government.
Now the proceedings is
we are not with a full hearing. Then the balance 2 crores, the single judge then said that if the amount is legally due, then the 2 crores should be paid by the government. Then we file a suit for recovery of 2 crores. That suit was contested and finally it was decreed that we are to get the 2 crores, remaining 2 crores along with interest, etc. etc. Now, I couldn't understand why they are pursuing with that.
See, Mr. Kantar, that is not the point. Here, I think we are on a technical point.
No, here
the issue, as has been, stated by Mr. Nopur, is only on the
point of maintainability. Condemnation. I challenged the condemnation.
You have challenged that.
By the court.
So that has to be.
We'll look into that.
That will have to be. That will have to be taken up by this court. And an order pass. This way, that way, whatever the case may be. which will have a bearing.
No,
In the appeal.
Which will have a bearing on as far as the proceedings before the trial court is concerned.
Before the appellate court, because we have
Before
filed an appeal.
First appellate
no,
court.
I'm just trying to brief the court.
Now, you see, what you have submitted here is a different aspect altogether. As far as your claim, right, title, whatever is concerned, that is a different thing.
Lordship.
If eventually you come to an understanding with the relevant respondents, as far as your right is concerned, or as far as the money is concerned, and then you can approach this court, and all subsidiary proceedings will be, can be closed.
Lordship.
That would be up to the party.
His senior colleague.
This court cannot go into that.
No, we're
because
just
that is
briefing you.
that is not the subject matter here.
Lordship.
So, because of all those issues, my colleague, Mr. Muzika, yesterday he said he'll take instruction
Fine,
Lordship,
but
whether to pursue or not to pursue.
I'll-
But I told him to ask Muzika to find out.
I have taken instructions, Lordship.
what did he say?
Lordship, we'll pray for time, Lordship. Let us take some
then-
instructions. Because here the subject matter is different, Lordship. Let us come after 2 weeks, Lordship. We'll take
That's
for-
what I'm
for
trying to.
instructions. Because here the subject matter is 8 crores, Lordship. So far as 2 crores is
You
concerned,
should have said that at the outset.
Yes.
That you
Lordship,
have,
we just want to brief this court.
yeah,
What is the matter about?
whatever the case.
If I would have started now, started.
Lordship, I apologize, Lordship. I didn't want to.
You have scared me.
No,
See,
Lordship.
Mr. Kanta said, I'll take 2 hours. And Mr. Sakri, so there will be in a fix. He's already in a list.
In fact, there are dozen judgments, Your Honor, in my favor.
The matter is
take
also
a-
pending for 12 years, so I don't know what is the initial.
Oh, that's a different thing.
Lordship.
If you see, that's not a concern of this court. What
Not
you
sure.
do outside the court is a different thing altogether.
They'll take instruction, there's no issue, Your Honor. He wanted to take instruction.
Mr. Bellumpir, counsel for the state respondent, has submitted that specific instruction is required as to how this matter is to be proceeded before this court. It is prayed that some time may be allowed for the same. On premier, the same is allowed. This is matter after 2 weeks.
Much open.
Item number 2.
Please, Lordship. Lordship, I have filed my rejoinder. The same may be listed for hearing on the next date, Lordship.
All the parties are present.
Yes, Your Worship, we have received.
Ms. Land Counsel for the petitioner has submitted that the rejoinder affidavit, the rejoinder to the counter affidavit filed by the respondents have been filed. And as such, pleadings being completed, this matter is now this matter may be posted for hearing. Accordingly, as prayed for by the parties, this is matter for. But this is only in the hearing list. Hearing list.
This is in hearing list, Your Worship.
I thought so. Yeah. And accordingly, this matter may proceed for hearing. Accordingly, as prayed for by the parties, this is matter after 2 weeks.
2 weeks, Lordship.
2 weeks.
Highly obliged.
Item number 3.
May I please, Your Lordship? The conducting counsel is, we are presenting respondent number 2. The conducting counsel is out of station, so we are seeking 3 weeks time, Your Lordship.
You're for respondent 2,
Yes, Your Lordship.
Mr. Mohanta.
Yes, Your Lordship.
And who's for 3?
All the respondent are on board.
On pray made by Mr. Letter Counsel for the respondent number 2, seeking accommodation on the ground that the landed senior counsel who is conducting the matter is indisposed. That is adjourned. As prayed for, this is matter after 3 weeks.
Valid.
Second call from supplementary list, item number 3.
His Lordship, I will try to shorten the argument. The earlier occasion, my esteemed colleague has addressed extensively, my Lord. I would take my Lord, your Lordship order dated 12/10/2023, framing the two issues at the time of admission of this very second appeal. And I would address, my Lord, on these two issues.
Yes.
My Lord, may kindly see order dated 12 October 2023. The two issues.
Yes.
My Lord, I would invite my Lord attention to para 6 onward. 6 and 7, my Lord. May I read, my Lord?
Yes.
Para 6. This court has given due consideration to the submission made by the learned counsel for the appellant and has also perused the memo of appeal and the contents of the violation submitted by the appellant. On perusal of the impugned judgment of the trial court as well as of the first appellate court, respectively, it would appear that there are issues of law which are required to be answered herein. Accordingly, this second appeal is hereby admitted. The issues of law suggested by the appellant appears to be relevant for consideration in due course, and accordingly, at this point of time, the suggested substantial questions of law are found suitable, which are formulated herein as under. Number 1, whether a first appellate court can grant relief to the respondent in the appeal in the absence of a counter claim cross appeal. Second is whether the provisions of the Transfer of Property Act 1882 have no application over the tribal areas of the state of Meghalaya in view of the operation of the Assam Frontier Tracts Regulation 1880. Now, these are the two issues, madam. The first issue is whether the first appellate court has granted relief to me or not. That is the first issue. In that case, my lord, before I go to the second issue, I would invite lordship attention to the pleading in the plain. It is available in the paper book. My lord, may come to the prayer portion in the plain, page number 10 of the paper book.
Yes.
My lord. Relief number 1, my lord, sought by the plaintiff, appellant. Declaration that the plaintiff's Shillong Club Limited is a lawful lessee in respect of the suit property and holds the suit property under a valid perpetual lease deed. So they are seeking, my lord, a declaration from the learned trial court. Please declare that the suit property is belong to the plaintiff under the valid lease, perpetual lease. Now, what is the suit property? Now, the suit property, my lord, may come to a vermin made in para 7.
Para 7 or?
It's para 7 of the paper book, page number 4, in the plain. Para 7 and 9, I'll take.
Yes.
7. That pursuant above, the plaintiff club went on to develop the suit land by making tremendous improvement on it. A world-class golf course has been established on it, which is not only used by the members of the club, but the grounds are also utilized by the general public and is a major tourist attraction in the city of Shillong. The plaintiff club is still using all the suit property and is very much in possession of the same. The plaintiff has, even after the establishment of the golf course, made various improvements on the suit property and has fenced off portion of it in an attempt to protect it. Now, number 9, that all these many years the plaintiff club has not faced any problem in respect of its possession over the suit property. However, lately some persons, since the clan has attempted to disturb the possession of the plaintiff club over the suit property. Nevertheless, all these attempts did not bear any fruit, and the plaintiff club continued to remain in possession and continue to utilize the suit property. Now, the description of the suit property, Lordship may find para 4 of the page number 2 of the paper book, my lord. Page number 2, para 4. Para 4, my lord. Towards the above stated objective of establishing a golf course, the plaintiff club entered into negotiations with the Thankyu Lightpo clan for acquiring some portion of the vast tracts of land held by the clan at that time. The negotiation was successful, and it resulted in the execution of a duly registered lease deed dated and such between the plaintiff club and the Thankyu Lightpo clan. As per the said lease deed, the Thankyu Lightpo has laid out the suit property described in the suit schedule herein below to the plaintiff club as lessee. Now, the suit property described in the schedule, my lord, schedule is available in page number 11. Madam, come to page number 11. Now, it's mentioned by the plot of land measuring more or less 10.19 acres in area, situated at such.
Yeah.
Now, this is the suit land. Now, this is a suit land they are seeking for declaring that the suit land of comprising of 10 acres, 10.19 acres, be declared as it belongs to the Shillong Club under what lease? Under the lease of 1923. This is the first relief. Now, my lord will see whether that relief sought by the plaintiff was rejected by the trial court as well as the appellate court, and any relief ever given to me or not. The issue has been framed that whether relief has been given to me without filing a counterclaim or not. Now, the suit was filed, my lord. I wouldn't take, my lord, go through again the list deed available in page number 14, my lord. I would, my lord, come to page number 19. 19. List deed is page number 14. Page number 19 is the letter. Now, for them, this is a cause of action.
Yes.
Cause of action arose from here.
Yes.
My lord, may invite lordship attention. So, the undersigned, who is the elder Rangpa of the Thankyu clan of Nongse, Milim Iskazil Meghalaya, have the honor to state that our predecessor interest as the owner and on behalf of the whole clan had leased out to your club a plot of land situated at Sanjit, measuring about total area of about 10.19 acres, more or less, bounded as under below. So this is a suit under the lease. We admitted that we have given you 10.19 acres under lease agreement. Now, the portion of the land on the south, under the area of dispute, as shown and indicated very clearly in the said schedule above, has never been utilized nor fenced properly, resulting in a massive encroachment. But since the neglected and unutilized portion of the land still remain with our Thankyu Lightpo land as the owners with the tree standing thereon, therefore we hereby have decided to take back into possession the said portion shown above, which is outside of the schedule leased out to your club, my lord, is very, very important. Outside, my lord, 10.19 acres, there is no dispute. The problem with the party here is the land adjacent beyond the 10.19 acres in the southern part. Therefore, he is the one who wrote this letter was saying that there is an encroachment in the southern part beyond 10.19 acres, and therefore we have decided to take it back. And there is a allegation of caution. May I just continue that one? Lease out to your Shillong club and not utilized or cultivated by any person. In this regard, we would like to make necessary arrangement with your club for amicable handing over by your club and taking over possession of my thank you land of the said plot within 2 months from the date of receipt of this letter representation. The last part is a rent, which is not the issue here. Now here, my lord, the author was trying to point out that the 10.19 acres is one, but in the southern part, beyond that, there is a encroachment. Therefore, we decided to take it back. It is a non-cultivated, no one used that one, but encroachment is there. Therefore, we take it back. Therefore, we inform you that kindly hand over. But there is allegation that the Shillong Club has constructed some cowsheds to accommodate some of the staff there also. So this is the letter. Now the dispute is we never claim, the respondent never claimed any inch of land within 10.19 acres under the lease. Now the plaintiff knows very well this position. Now
let's go back to the lease.
My lord.
It mentioned that 10 point.
Yes, my lord, may come to page number 14.
This is the schedule.
The schedule is there, my lord. Scheduled, my lord. Now, thus
10.19.
hereby lease, my lord, lease in perpetuity the said land covering an area of 10.19 acres more or less of the upland from 1st April 2022 to the General Secretary, Sports, Sunset Shillong Club, and the successor in Sunset in consideration of the payment of the annual rent for 20 years from 1st April 2022 till 31st March 1944 at rupees such and such. So it is very clear. The leased land is only 10.19 acres. We never dispute. Now the problem, the background, my lord, why this problem arose and how the plaintiff is trying to take advantage of this is the, my lord, I would invite my lord attention to original lease, 1914 lease, available by type copy, my lord, page number 42A of the paper book.
Yes.
My lord, this schedule is the same schedule. Now it says, thus hereby lease in perpetuity the said land covering an area of 16.91 acres more or less for a term of 10 years from 1st April 1914 to 31st March 1924 to the Secretary Shillong Sports Club and his successor hereinafter called the lessee in consideration of the payment annual rent for sunset yearly in advance in the month of April on the following terms and conditions. My lord, the terms and conditions absolutely same. Only, my lord, here it says Shillong Sports Club. In 1923, they used the lessee. The remaining terms and conditions remain the same. Now, originally, we have given this land to them, 16.81 acres. Subsequently, we realized that we need some land, the land itself need. Therefore, we take it back 6 acres. Now, in view of that, they reached another lease agreement in 1923. Now, my lord, can you see
by that 1923 lease agreement?
Yes.
Whether this lease of 1914,
yes,
has it been superseded?
My lord, that is the claim of the plaintiff, the defendant here, my lord. My lord, can you see page number 16? 16.
Yes.
My lord, may kindly see the ending paragraph.
Oh, yes.
The previous lease, which is current till the 1st March 1922, is hereby cancelled. My lord, make it.
Yes.
Lordship got it. My lord, this is the lease they refer to the 1914 lease.
But here it says 2022. Here
My
it
lord, may
says,
come to, yes.
here it says 31st March
My lord, to
1924.
clarify this one, my lord may come to page number again, 42A, the first list.
Yes.
My lord, this lease is for 10 years,
Yes.
with effect from 1st April 1914 to 31st March 1924. It is mentioned, Lordship,
Yes.
1924. Now, this in page number 16, they have mentioned 1922. It was a 31st, date also 31st, month also March. Only, my lord, 22, they mentioned instead of 24. Only that one. But the party understood that this is the agreement between the parties, therefore, we take it back 6 acres, remaining keep with you.
But this was executed in 23.
The 23. Now, with the effect, now, therefore, they could have mentioned, my lord, they could have mentioned, my lord, 2024.
Yes.
In 1924, 23, when they enter this new agreement, they should have mentioned the current lease agreement that is current till 31st March 1924. Instead of mentioning 24, they mentioned 22. But the parties, there is no crisis. They understood both of them. Both parties understood they were okay. So that they are well least bothered about that. Now, therefore,
Okay, so that controversy was not raised.
controversy not raised. If there was a controversy, it should have been resolved between the parties or before the competent court of law at that point of time. No one raised. And therefore, when they reached the second agreement, lease agreement, there was a changes of the area. Now the north-west east, the boundaries, they restructure it. But when it comes to southern portion, they did not order the boundary. Therefore, there was a discussion among the parties that we did not change the boundaries in the southern part. But the parties in the Shillong Club said, we know that it is not our land, it is your land. We are only a lessee. So there is no problem. We will never claim it. So because of that amicable understanding between the parties, no dispute arises. Subsequently, they raised some cautions. Therefore, they pointed out by their 2013 letter that we will take it back. So that was the letter. Now they took it as a course of action. And they filed a suit to declare which portion, my lord, 10.19 acres, where I don't have any dispute. So therefore, this the suit is methodically framed because the Shillong Club cannot claim land beyond 10.19 acres. There is no lease agreement. And therefore, they, my lord, properly structured the spider suit that a suit land. But the claim is beyond the lease agreement, lease area. Therefore, even, my lord, the lease agreement is declared as belong to the plaintiff. They are entitled only 10.19 acres only. They cannot claim beyond. But the actual claim on the ground is they are claiming beyond 10.19 acres. That is a dispute. And Lordship may keep in mind, they did not disclose which area. Assuming that we are claiming the suit land, which area there is a dispute. They don't disclose in the plea. Evidence in chief also, cross-examination also, they don't disclose. Which area there is a dispute. Even the plaintiff himself, in the cross-examination, he even did not know the actual area of the lease area, 1923 acres, 1923 lease agreement. He admitted. And number two, he admitted that we are not claiming the 6 acres. We are claiming only 10.19 acres. 10.19 acres, we have given them 1923. Till date, we are not claiming. Now, this is the issue. Therefore, my lord, in my letter, page number 19, written on 18 January 2023, it is very clear that the dispute area is outside the lease agreement, lease area. They shouldn't have any dispute with that. But now, therefore, they filed this suit, and now my lord, I have filed my WS. In my WS, my lord, may I need page number 33.
Yes.
My lord, para 7, 9, 11, my lord, 14, 15, 17, 18, my lord. I will not read through, these are my notes,
Para
we kindly noted.
7, 9,
Para
11.
7, 9, 11, my lord,
Yes.
14,
Then
14, my lord, and 15, 17, and 18.
yes.
But we made it very clear that the plaintiff is attempting to grab the land beyond this area. This area. My lord, we come to para 14, my lord.
Yes.
Para 14. That the averment made in para 3 and 4 are outright separation and distortion of facts which nullify intention, ulterior motive to illegally grab other portions of the land of the defendant landlord that was not leased to the plaintiff's club, and such, and hence denied by the defendant. The real and actual facts belie the contention of the plaintiff and is put to strict proof thereof. In reply, it is stated that the predecessor interest of the defendant on such leased 16.91 acres of land to the predecessor interest of the plaintiff's club. Thereafter, due to non-bona requirement and on mutual understanding, 6 acres of land situated to the south of the leased land was taken back by the predecessor interest of the defendant. A fresh list dated such was executed only for an area of such acres and such. Few days after execution of the fresh deed, it was discovered that the boundaries in the said fresh lease to the south remain unaltered, like the previous one of 1914. The then predecessors of the defendant raised this issue before the then members of the erstwhile Shillong Sports Club for causing necessary correction to the said deed. However, the then members of the plaintiff's club assure that they too are a man of words who keep their words as well, and they would never question the landlord's title nor encroach into the predecessor's land beyond the allotted such acres on the mere minor technical defect in the boundary in the document. And the predecessors of the document defendant accepted that assurance. The plaintiff has currently feigned ignorance of this fact and suppressed the same for this ulterior motive. And when we got down, my lord, 1923, the said portion of 6 acres remained in the absolute possession and occupation of defendant and his land, where he had also these certain portions in and around the said land to different tenants by issuing patas to them without any objection from the then members of the plaintiff club as assured by their predecessors. In 1991, the defendant leased out such square feet to the third portion of Provinces where they had constructed a community hall and remained in their occupation till date. On 1996, an area of Sunset square feet was leased out to Srimati Sunset, where she constructed the house and remained in her occupation till date. 2000, then an area of 9 Sunset was leased out to Srimati Sunset, where she constructed the house and remained in their occupation till date. 2011, an area of square feet was leased out to Srimati Sunset, where she constructed the house and remained in her occupation till date. And 2011, an area of such square feet was leased out Sunset, where she constructed a house and remained in her occupation till date. The plaintiff's club never raised any protest in this regard. But now all these are within the 6 acres, leasing out to 5 the pata holders. They never raise objection. Only they take advantage of the content of my letter. We say that we request you to take to hand over. as if we are asking them to give some land from their side. So all these are 6 acres, and they do in the cross-examination in chief, they admitted. Objection never raised. In view of that, my lord, the trial court found that you never raised objection. And the area of your dispute is in this area. Forget about the 10 acres, 10.19 acres. But the 6 acres, these allotments are given. And if your suit land comprises of these 6 acres, it will become a 16.91 acres again. Therefore, the learned trial court has dismissed the suit. That the principle of estoppel applies to you. Therefore, you cannot raise this issue anymore. So that is my lord, the decision of the trial court. May I just take a few cross-examination paper. I'll come to other point. My lord, we come to page number 84. Cross-examination of the plaintiff.
Yes.
My lord, the last line, my lord, page number 84. There are 2 houses located to the south of the Shillong clubhouse. The houses belong to the village Darbar of Sons in Kofling. It is not a fact that the defendant Thankyuk land has allotted the land to the said village Darbar. Shillong Club has not allotted the plot of land to the village Darbar of Sons and such.
What is this? It is not a fact that
Now they are disputing that the plaintiff club, the defendant did not allot it, this plot. Then who allot? If they are the landowner, they are supposed to allot it. They did not claim that we allot it.
it is not a fact that the defendant has allotted the land. So that means you have not allotted.
They are denying that I allot it. They are disputing. They also say that I did not allot it, so also they did not allot. That is what they say. I would understand I did not allot it, but they allot it. We understand. But both of us not allot. The reason why they cannot take the plea that I allot, the Shillong Club can allot, the law doesn't permit them to allot. They are non-tribal entity, Shillong Club. It is a tribal area. They know this position very well. Now, when we read down this further, my lord, I'm not aware whether the Shillong Club has raised any objection when the village Darbar constructed the 2 houses in the said plot of land. I'm not aware whether, my lord,
Yes.
the club has raised any objection when the defendant allotted portions of land situated to the south, club house to the Srimati Irali, Hinoda, Srimati Sunset, Victoria, and Srimati Maigreta, where they constructed their respective houses. They didn't raise money. They admitted.
Yes.
The houses are standing just in front of their plot. They were supposed to raise the objection. But they didn't raise. And now my lord may come to page number 87. My lord, in other words, no claim has been raised by the club in respect of 6.72 acres which apparently relinquished in 1923. Relinquishing they are talking about. I cannot tell before this court where is the actual location of the 6.8 acres, as the main concern of the club is the area of 10.19 acres. It is not a fact that the 6.72 acres is situated to the south of the club house. It is a fact that in the plain as well as in my evidence in chief, it is admitted that the Shillong Club had taken on this a plot of land from the premises of the defendant. But at the bottom, it is a fact that the Shillong Club does not know that particular firm or institution by the name and style, named as Shillong Sports Club. Well, that was a dispute. Initially, there was a nomenclature of the club at that point of time, but they deny it. Now, may I come to page number 90, my lord?
19.
90, 90, right?
Yes.
In the third line, my lord, I am not aware of the location of the original document dated 20 March 2023. This is a lease agreement they are claiming about. I did not produce before the court today. It is, however, in our possession. It is not a fact that the particular firm by the name and style sports section does not belong to our club. Now, may I come to page number 92. My lord, in that second line, it is not the fact that none of the members of the club were present during the inspection. Now, it is important, it is not the fact that the club has failed to show the location of 10.19 acres of land. Our club is not concerned about the 6.72 acres. Now, their disputes fall within 6.2 acres, 92 acres, 72 acres. I've given 10.19 acres long ago. I don't claim it back even now, when they filed the suit. Now, if they succeed their suits, my lord, these 16.72 acres will be with them. And it will be, total area would be 16 acres again. This is how the attempt was made. I cannot say whether the club is claiming on that 6.72 acres of the 72 acres of land or not. But I cannot, my lord, I cannot comment whether the club has any reject to challenge the local inspection conducted by the courts. So admittedly, the case of the plaintiff was that he fails to show where is the exact area of dispute. Because in my WS, I made it very clear that I never claimed 10.19 acres. It is yours under the lease. Now, therefore, the question was put forward, where is the exact location of 6.72? He said, I don't know. And we don't object when the construction takes place. And in one way, they said that even I do not know the exact location of land mentioned in the 1923 list. But subsequently, they said, no, I can show. This is the quality of the evidence adduced by the plaintiff appellant in the trial court. Therefore, the trial court, my lord, deem it fit. Trial court order. The reason, my lord, why I take few facts, my lord, we are very much aware, lordship is very much aware, the jurisdiction of my lord in the second appeal. But few facts, my lord, I'll place it, then I'll come to that that substantial question of law. My evidence also available, page number, my lord, 94 onwards. I mean, my cross-examination also available in page number, my lord, 111. My cross-examination. Very short cross-examination. The defendant respondent was allowed the face.
This is cross of
the defendant.
Defendant.
Well, very short.
By the way, there are only two witnesses.
Yes,
I mean, one witness from each side.
From each side. Yes. Yes. Well. And in view of this, my lord, the trial court has passed the order, page number 122. And then may I come to the, my lord, the issues framed by the trial court, page number 105, 115, well, 115.
Yes.
The first issue, my lord, upon perusal of the pleadings, the following issues were framed by my learned predecessor in office and such. Number one, whether the parties enter into register lease deed dated such and such. Whether the said lease date such and such was to be leased in perpetuity. But regarding these issues, the trial court found that yes, there is a lease between the parties. Number 3, whether the defendant by lease 1914 lease out such to the club, and thereafter by the lease date 2023 reduced the area and lease out only such acres of land to the plaintiff's club. If so, whether the 6 acres of land situated to the south of the golf club no longer leased to the plaintiff's club stood reverted back to the defendant and his land since 1923. But this was disapproved by the trial court. It has no connection, it is not proof. Whether the defendant issued letter such expressing an intention to take back into the possession the southern portion of the suit property. And that one my plaintiff not claim. Here the plaintiff not claim, since not claimed 16 acres of land. That was, it is irrelevant. Number 5 is important, where the trial court laid its foundation. Whether the plaintiff's claim raised any objection when the defendant leased out portion of the 6 acres of land to the third party of such to Srimati Malahinuda, Srimati such, Srimati Victoria, Srimati Maigrita, where they have constructed and taken possession of the suit property. They said there was no objection. Now, whether the suit parties are entitled to any relief or not. Now, therefore, the issues, Lordship, kindly page number 5. The trial court was focusing that the issue is the dispute between the parties is focusing in the 6 acres. Because of my admission that 10.19 acres there is no dispute. Therefore, the trial court is kneeling down to this issue. The dispute is that one. And therefore, the finding arrived at this issue number 3. My lord, issue number 5. My lord. May I come to page number 117. These are the findings of the trial court.
Yes.
But issue number 5. Defendant on his deposition on affidavit has stated that all members of the plaintiff club did not raise any objection when a portion of the say 6.72 acres of land was leased out to the person of such on an area of such square feet where they constructed the community hall, to Srimati such for an area of such square feet where she constructed her residential house, to Srimati such in 2010 for an area of square feet where she constructed her house, to Srimati Victoria in 2011 for an area of such square feet where she constructed her house, and Srimati such in 2011 for an area of such where she constructed her house. Defendant witness such has exhibited such. Shanpur Singh, plaintiff, he is the plaintiff, has stated in his disposition on affidavit that when the plaintiff club was saw the advertisement in the Shillong Times, such offering a sale of such, and the plaintiff lodged a formal objection such with the sub-registrar such. Mr. Prince Singh has also stated in his cross-examination that he is not aware whether the Shillong Club has raised any objection when the village park constructed 2 houses in the said plot of land. Mr. Singh also stated in his cross-examination that he is not aware whether the club had raised any objection when the defendant allotted portions of land situated to the south of the club's house to Srimati Sunset when they construct their houses. Mr. Param Singh has exhibited Sunset. This court has perused exhibit Sunset and found that the plaintiff club did not make any objection when the defendant allotted the plot land to the third person of Sunset, Srimati Henuta, Srimati Nangsa, Srimati Victoria, and Srimati Maigrita, but only in the year 2013 they started in making objection in general. In fact, the defendant had allotted the plot in the year 1991 to the third person of Sunset. The plaintiff club has never raised any objection on this, and according to Section 115 of the Evidence Act, the plaintiff has power by estoppel. So this is the finding, my lord. Now, since, my lord, the defendant did not claim any land over 10 acres, there was no deliberation. deliberation. Only, my lord, the area of dispute is within 6 acres. Therefore, since you never raise it, estoppel will apply. Suit dismissed. The suit is dismissed, my lord, page number 118. The suit is dismissed on contest. Both the parties will be at their own course. Prepare decree accordingly.
Yes.
Now the suit is dismissed. Relief claimed by the plaintiff was not given. Now the content of the order, where is the relief given to the defendant? No relief given to me. This is the position. No relief is ever given to me. If the trial court did not stop dismissing here, however, travel further and give some relief to me without counterclaim.
No, see, the contention is no relief was given to you because you have not filed a counterclaim.
No counterclaim. Yes. And therefore, my lord, the contention would be correct if the trial court give me some relief without counterclaim. But admittedly, there is no relief given to me. Now, no relief was given to me, and they prefer again a first appeal. In the first appeal, they have taken the ground. The relief was given to me. My lord may come to the first appeal they filed. In the ground, I will come. They have taken 4 grounds, in fact. Only 4 grounds. My lord may come to page.
I think we'll have to continue.
Yes. Yes. My lord.
Chief has come. Yes.
Subject to lordship convene next week. Tuesday, Wednesday. So next week I will conclude. I'll try to conclude.
My lord, next week.
My friend would be.
See, conclude. See what? Kano? Kano nó có sự kiện lạnh nhỏ cả nhiều vật cả hôm nay phá cần đai cần quý những gì mà không cần luôn ha we'll continue on it
With you.
heard Mr. H.L. Sangresu led senior counsel for the respondent. The argument will continue on the next date fixed. As agreed to by the parties.
My lord, subject to lordship, my lord, permission, if matter fixed on 9, my lord.
9, you see, because 9 is a Wednesday.
9 is a
So
Wednesday.
we have to DB on that day. I don't know how it goes.
Nine. 7 is Tuesday.
Should we do it on 11th?
11. 11. Well,
No. This is matter on 11th.
well,
For further hearing.
yes, understood.
Chief Lawan.